better. But the thing is, there are a lot of the big concern is about enforcement method. Currently, there are different channels for IP right enforcement. They are private settlement, and you can sign a settlement agreement with the infringing party, and so that you can get the injunction from them to the further infringement. And also there is the administrative enforcement, and you can do that from they call enforcement agencies, and including Chinese Trademark Office, State Intellectual Property Office, and National Copyright Administration in its local branches. And also another way is customer protection. This way is good for companies selling goods in China or distribute goods in China. So basically you can register the products with the Chinese customer. When there is any infringement happen, the customer will immediately notify you so that you will know what the next step would be. And also another channel is arbitration or civil litigation. Basically you cannot do both. You just can do either way, either arbitration or either litigation. But you have to set up the arbitration clause in the contract. Without the arbitration clause in the contract, the only way you can do is just to go to the civil court. But if you set up the arbitration clause is not so clear, and probably arbitration bureau will not hear the case too. So it's very important to set up the arbitration clause if you want to go with this way. The final solution, enforcement in China, is criminal prosecution. So, but this is very harsh to prove there is any criminal against the infringement. So that's basically there about intellectual property. Another thing I want to mention is that for the relationship with your employees. So I think the practical solution is to have a contracting with your customers or suppliers or distributors, and also having contracting with your employees. Basically, and also you have to set up some internal information access system and information access tracking and record keeping system, so that you can track what kind of information to be accessed to certain employee and what's the information disclosed or not. So that is basically the practice suggestions. And also another thing I want to mention is in China, the non-compete agreement and confidential agreement with employees are enforceable too. So you can set up the separate agreements with employees or put these clauses in the master employment agreement. And also you can take full advantage of Chinese anti-unfair competition law. This is good for you to protect your unpatented trade secrets. So I think basically the situation is getting better, but the thing is you have to do your homework in advance. You have to contract on this.
Sure. I have a question related to your contracts with employees. So we used to have a representative office, and now we have a WFOE. And we found that there are a number of differences in how Chinese nationals are treated versus how foreigners living in China are treated in terms of employment law. And my question is, with regard to NDAs and non-competes, are those equally enforceable for both Chinese nationals and foreign employees within China? Or is there a difference in terms of enforceability?
Can you repeat the question?
Yeah, for those of you that didn't hear the question, it has to do with whether non-competes for employees in China are enforceable, not only for local Chinese people, I think, but also for foreigners who might be actually doing business there. Because, and you used a term, and I'm not sure everybody knows here, it's WFOE. It's a wholly owned foreign enterprise. That's how most companies go into China. It's through a separate entity, which will then actually employ the employees. And here in California, of course, non-competes are typically not enforceable in an employment context. So it's a little bit of a different way of thinking, to go to a country or even another state to do that.
Yeah. Okay, so theoretically speaking, and it's equal to both kind of employees, for the foreign expatriate employee or the locally held employees. And from practical issue, and sometimes they may have balance. they may have some counterbalance. But if this case goes to the court, and the court definitely they will look into some fact issue to say what kind of if it is a disclosure or that is a competing, they definitely will based on the employment contract to do the work. But for the WUFE, and because the WUFE can independently hire employees locally, so it's required by the law you have to sign the employment contract with the employees. So, and the court, when the court hears the case, they will based on the clause of non-competing or non-disclosure clauses to make the judgment. But for rep office, because rep office cannot independently hire employees, they have to do that through a FASCO. This is a foreign enterprise service company to indirectly have the employees. So the contract will be signed through the FASCO. So if there is no any clause in the contract, the court will just use a basic, the minimum legal requirement to judge the case. But typically, I think probably they're the same. Yeah, seriously, it's the same.
But Roger, before we jump off the IP point, I mean, I just want to say, in my experience, companies are getting increasingly more comfortable about not just allowing intangible property to be utilized within China. And usually, when they have a presence like a WFOE there. So companies are definitely getting more comfortable with allowing IP within. But actually, I'm seeing a lot more actual real R&D and real intangible development taking place within China. And that's been a trend that's been picking up for several years now. And my background, again, is more in corporate international tax, and that is presenting a lot of interesting challenges on the tax front. Historically, if you look at Chinese transfer pricing rules, the Chinese taxing authorities have been, they've allowed relatively modest earnings in China because usually there hasn't been a lot of intangible development or exploitation. That's starting to change. They're starting to expect to see better returns, expect to see that some of that intangible being actually utilized and exploited within China. And so now you got a little more of the classic, tug and pull between, China and the U.S., where both are kind of wanting to pull at common earnings from intangible properties. So, I've seen a lot more of it, and it's really starting to present some interesting international tax challenges.
Anything else, or do I get to ask another question? So a lot of my clients, I'm sorry, somebody, hi Hannah. You're just waving at me, or did you have a question? Okay.
And my question is, if the contract is set up, like you said, if the contract is set up right, what is the chance of a foreign company getting their data in court? Is it as good as, say, in the American system, or, so if you want to enforce against a good contract that you established with a partner or, service provider, and you want to enforce that contract against a Chinese company, what is the likelihood that you actually get your data in court and that the proceeding will be fair? And all that.
So let me restate it. So Hannah, for those of you that didn't hear it, the question has to do with enforcement of contracts, because I think we've all heard that, unlike the U.S., where there's a lawyer in every corner, in China there's an engineer in every corner, and not a lot of lawyers. So it may be that people are just not that litigious. They don't expect to go to court. Maybe the court system isn't really set up to deal with disputes, as many disputes as here. So the question is, what is the paper in China that the contract's written on?
Okay, so in your situation, we already exclude the arbitration, so directly go to the court. So if a case goes to court, basically because the foreign company is going to sue the Chinese company, the guy in China, and based on the theory of contract law, you have to go to the local court where the defendant residence in. And then you have to prove some, you have to file a complaint first, and then you have to do some, there is no the real discovery like the United States have in China. So, but you have to provide some evidence to show the infringement before the judge, and also the judge may do its own independent discovery to figure out what's happening over here. But for better protection, if you have enough evidence, you can request injunction order.